Hi everyone, this is Daniel Tekunoff. In this video, we're going to review Patrick Henry's warnings about the Article 5 Constitutional Convention Clause. After the U.S. Constitutional Convention and the Constitution was written, it goes out to the state ratification conventions. Virginia's State Ratification Convention starts on June 2, 1788. After some preliminary matters, it begins deliberations on June 4, and Patrick Henry speaks right from the beginning against the Constitution and for at least amending it. And on June 5, he picks up the discussion. And he's saying, to encourage us to adopt it, they tell us that there is a plain, easy way of getting amendments. The way to amendment is, in my conception, shut. Let us consider this plain, easy way. Then Henry focuses on the ratification process for amendments, that 3/4 of the states ultimately must agree for an amendment to become part of the Constitution. And what he's saying here is that some of the most unworthy characters may get into power and prevent the introduction of amendments. Will they ever relinquish powers already in their possession or agree to these amendments? Then Patrick Henry, like really every other scholar who's looked at the Article 5 Convention Clause, concludes that 1/20th part of the American people could prevent the removal of some of the most grievous inconveniences and oppression by refusing to accede to amendments. And we see comments about this all the way up to the modern day. Justice Antonin Scalia, who has been recently passed away, made comments himself during his lifetime about the Article 5 Convention Clause, and we will get to a video about that sometime later on. Then Patrick Henry, considered really one of the best orators of that time, states that it is, sir, a most fearful situation when the most contemptible minority can prevent the alteration of the most oppressive government, for it may in many respects prove to be such. Is this the spirit of republicanism? And this is part of the definition of free government here. A republican form of government should allow the people to make changes to the Constitution without there being such a barrier that you can't get it done. Then Henry goes to the Virginia state constitution, and he states here, what, sir, is the genius of democracy? Let me read that clause of the Bill of Rights of Virginia. Whenever any government shall be found inadequate or contrary to those purposes, a majority of the community hath an indubitable, unalienable, and indefeasible right to reform, alter, or abolish it. This, sir, is the language of democracy, that a majority of the community have a right to alter government when found to be oppressive. But how different is the genius of your new Constitution from this? How different from the sentiments of free men, that a contemptible minority can prevent the good of the majority. If, sir, amendments are left to the 20th or 10th part of the people of America, your liberty is gone forever. Then Patrick Henry closes out this part of the discussion by referring to the working class and states here, I dread the operation of it on the middling and lower classes of people. It is for them I fear the adoption of this system. Will the great rights of the people be secured by this government? Suppose it should prove oppressive. How can it be altered? So now we move to the next day, June 6, and James Madison has had a night to think about the things Patrick Henry has stated, and Madison comes up and he says, we're flattered with the probability of obtaining previous amendments. This calls for the most serious attention of this House. If amendments are to be proposed by one state, other states have the same right and will also propose alterations. Here, Madison is talking about the Article 5 Convention allowing all states having delegates that can propose amendments. There cannot be a shut-off of what is proposed at the Constitutional Convention by the state legislatures ahead of time as a condition to starting the convention. And Madison explained some of the reasoning for this here. He's saying that the various state legislatures cannot but be dissimilar, and opposite in their nature. He begs leave to remark that the governments of the different states are in many respects dissimilar in their structure. Madison goes on to say that this dissimilarity has occasioned a diversity of opinion on the theory of government, which will, without many reciprocal concessions, render a concurrence impossible. What he's saying here is that at a future constitutional convention, if there is not basically a wide open discussion about how to amend the Constitution, then you don't have that opportunity for what he's calling here reciprocal concessions, basically trade-offs. And if you don't have that opportunity, you're never going to get agreement on necessary amendments. Then here, also on June 6, another delegate, Wilson Nicholas, backs up James Madison. He's referring to Patrick Henry. That's how powerful a personality Patrick Henry was. They're all kind of going up against Patrick Henry. And here's Wilson Nicholas. He thinks amendments can never be obtained because so great a number is required to concur. Had it rested solely with Congress, there might have been danger. The committee will see that there is another mode provided besides that which originated with Congress. So here, Mr. Nicholas is referring to the Article 5 Convention, but note that in other videos we've shown this is where we have a major problem in the U.S. Constitution. We've called it the devil's loop of the American Constitution, where so far Congress has been the only body proposing constitutional amendments to the U.S. Constitution. We've never used the Article 5 Convention of the People, and we don't have evidence that it works, and so we probably should use it to make sure it can work. And here's Wilson Nicholas continuing that on application of the legislatures of 2/3 of the states, a convention is to be called to propose amendments. Notice that plural, amendments, and that these conventions will have many advantages over the original constitutional convention in the matter that there are no experiments to devise, the general and fundamental regulations being already laid down. He's basically referring to the theory of free government, that the people should vote for their own representatives and the various other things that go along with that, including being able to vote for your own representatives to go back into a constitutional convention and propose amendments. Then here we advance to June 10 of 1788, and here is a young John Marshall, who will later become probably our most famous Supreme Court Justice, Chief Justice. And here he takes up a big role in arguing in favor of the Constitution. He's saying here, is not liberty secure with us, where the people hold all powers in their own hands and delegate them cautiously for short periods to their servants who are accountable for the smallest maladministration? It is the people that give power and can take it back. Then Marshall continues, the objects of your adoption are union, safety against foreign enemies, and protection against faction, against what has been the destruction of all republics. These impel you to its adoption. If you adopt it, what shall restrain you from amending it if, in trying it, amendments shall be found necessary? And this is really interesting too, because this is part of the guide for us if we should go back into a constitutional convention. We're still looking to support union, safety against foreign enemies, and protection against faction. The idea would be to use these as sort of the center of arguments about what clauses should be amended and which ones should stay the way they are. What comes into view in this part of the ratification process where the Virginia State Ratification Convention is meeting is a two-part promise. The state ratification conventions are ratifying the Constitution, but with a list of amendments that they want for a Bill of Rights that would protect individual rights. But there's a second part of the promise. They're asking people not to make changes to the structure of the U.S. Constitution until experience will teach us where those defects are. And here is John Marshall's passage which summarizes the second part of this promise. When experience shall show us any inconveniences, we can then correct it. But until we have experience on the subject, amendments, as well as the Constitution itself, are to try. Let us try it and keep our hands free to change it when necessary. If it be necessary to change government, let us change that government which has been found to be defective. It's a clear reference that experience will show us the defects in the structure, and that is when we should make the changes. Then Marshall states, any amendments in the system before you will not go to a radical change. A plain way is pointed out for the purpose. All will be interested to change it, and therefore all exert themselves in getting the change. Clearly, Marshall sees that whenever there is discussion about a constitutional amendment, it should be open for everybody to give their view, so that everybody has a chance to make whatever the amendment is as good as possible. And here's another quick bit of evidence of how the framers considered that whenever it was either Congress or a constitutional convention discussed constitutional amendment, that the entire system was open for discussion. Here's Delegate John Tyler on June 14, saying that he hoped that when amendments should be brought forward, they should be at liberty to take a general view of the whole Constitution. And James Madison confirms this. He says he agreed with the gentleman that when amendments were brought on, a collective view of the whole system might be taken. This is Madison's sort of way of talking without making a full commitment, but he's confirming that the theory of free government means that when you talk about constitutional amendment, you talk about the entire Constitution. That's what allows the amendments to finally be made, that everybody has a chance to be part of the discussion. Here's a couple days later, on June 16, 1788, John Marshall again, a foreshadowing of a future case. He states here that the state governments did not derive their powers from the general government, but each government derived its powers from the people, and each was to act according to the powers given it. After the McCulloch versus Maryland case in 1819, there was some hard criticism of that case, and John Marshall wrote under a pen name, "A Friend to the Union," 2 articles that first appeared in a Philadelphia newspaper, but they were in the wrong order, and so they reappeared later on in the Alexandria Gazette, I believe is the name of the paper, and then later on that same paper also published another 9 articles under the pen name "A Friend of the Constitution," also written by John Marshall. The point being that the very first "A Friend to the Union" article is what motivated Marshall to come out. And what he said in that article was that the Article 5 convention for proposing amendments is a convention of the people where the delegates will be elected by the people. And that is really the main motivation for his last ever writing outside of court opinions. Now here we're going to go to near the end of the convention. It's June 24, and we're going to close out with Patrick Henry. And he, again, at the end of the convention, he goes after how difficult it is to get amendment, again focusing on the fact that 7/8 of the people of America may wish the change, but the minority may come with a Roman veto and object to the alteration. Then here's Patrick Henry on June 25, just before the Virginia State Ratification Convention is going to vote in favor of the new U.S. Constitution, but with a list of amendments that they're going to send into the first Congress asking them to make. And this is a warning to the future that the proposition of subsequent amendments is only to lull our apprehensions. For further study, I invite you to take a look at my book, Guide to the First Article 5 Convention of the People.